Hi, David Campanile here, owner of Campanile Law, located in the state of New Jersey. We handle estate planning and probate. Today's topic is going to be about the 5 ways to avoid probate without getting a revocable living trust. But before we dive into this topic, if you have any questions pertaining to estate planning and probate, and you want to schedule a free strategy session over the phone with me, head over to njestateattorney.com, schedule a day and time that works best for you. So, 5 ways to avoid probate without a revocable living trust. I can guarantee there are more than 5 ways. In New Jersey, 4 of these 5 ways will work. The one way I'm giving you does not work in the state because we do not honor it. So we're going to go from my least favorite to my most favorite. And at number 5, we're starting off with what New Jersey does not honor, which is a transfer on death deed. But before we dive into this, David, what is probate? And as we all know, probate is the transfer of property from a deceased individual to their living heirs. And it's an organized way to do this. So number 5, a transfer on death deed. Well, when do we use a transfer on death deed? I'm glad you asked. So you own a home, and what you can do in other states is you can file a deed that says, from me and the missus to X and Y when we pass. When the last person passes away, or the last owner passes, these people will own the property. And so me and the missus pass, X and Y go in with our death certificate. Whoever passed last goes, hey, property's ours. They're down at the county clerk's office. They're all giddy because what happened? They magically own that property now because that transfer on death deed that was filed, eons ago now is now fully recorded and they are now the owners. We can't do that in New Jersey. So that's a no-go, least favorite. Number 4, gifting. David, gifting's a great way to handle things. That's the best way to avoid probate. You're wrong. Let me tell you. So, 2 reasons why I have an issue with gifting. Number 1, you can't get it back once you gifted it. That's why it's called a gift. So imagine giving someone $17,000 right now that in 5 years you're going to need. You can't go get it back, folks. Strike 1, why I don't like gifting. You basically have given up control of an asset to somebody else and said, hey, I don't need this, I don't want it, it's yours, take it, get it out of my estate, get it out of my hair, but now I need it. There will be no Indian giving here. And number 2, and I am, again, think about this, now we get into a little bit more of the legal stuff. If it's property, you're going to lose, or anything really, you lose your step up in basis value. And what do I mean by step up in basis value? So imagine you bought a home for $100,000, right? You live there 50, 60. You bought the home when you're 25 years old. You've lived there for 60 years. You're 85 years old, and you kick the bucket. And now your kids come in. And that home that you spent $100,000 on 60 years ago is worth $1 million. Whoa, that's an investment. Your kids get that property at the value of $1 million. They're not going to pay the tax between that $100,000 and that $1 million. That's a big step up in basis, right? That's a huge tax relief taken off their shoulders. So now imagine this. You gift them that property. They're going to have to pay, depending on how you do this, a real estate transfer fee in the state of New Jersey. And there's a potential of a 20% tax hit because of that step up in basis, because now they're getting it at that $1 million. So a $900,000 investment, that's $180,000 in taxes. This is not a good way to do this. This is not profitable. This is not... Forget profitable. This isn't smart. It's not wise. I would be against it. That's number 4. So we don't like gifting. Number 3, is going to be a, is going to be a transfer on death. And what do I mean by this? So when it comes to your bank accounts, when it comes to assets, normally bank accounts, what we can do is you go to the bank and say, hey, look, I want control of these accounts, but when I pass, make sure it avoids probate, transfer it to, these individuals or this particular individual. They give you like a 1 or 2 page form. You fill out some basic information, give it back to the bank. Make sure you give it back. People fill out these forms. They put them, with their estate plan or somewhere on a shelf, and they forget to file them. Make sure you file that form with the bank. Then what's going to happen is when you pass away, the bank is going to call so-and-so after your executor or whomever, or maybe, your beneficiary walks in with a copy of your death certificate, says, hey, David passed. Give me my bank account. And they'll look at the death certificate. They'll file the appropriate forms, make you sign a couple forms before they release everything to you, and you'll walk out with those things. And that will pass outside of probate. Easy squeezy lemon peasy. This used to actually be referred to as the poor man's will. This is how a lot of things were done. Number 2. So now we're getting into more of my favorite ways to handle things. Is joint, well, this one is kind of a tie. I probably would flip-flop now that I'm thinking about it, 2 and 3. But at number 2, we have joint tenants with rights of survivorship. And this is how a lot of property in New Jersey, especially between married people, is titled and deeded. So, example, I always use my home is deeded to husband and wife as joint tenants, as husband and wife. That kind of just refers to as joint tenants with rights of survivorship. So if I pass, there's 100%, and we each own 50% of our home. If I pass, my wife being the joint tenant with me gets my 50%. I can't instruct it to go to, my child. I can't instruct it to go to a parent of mine or to a friend of mine. My wife will, in essence, absorb my 50%, taking our 2 halves and creating one whole in her. And now she can do what she wishes with that property. She can sell it and get all of the proceeds. My estate does not get that 50% of the property because of how the deed was titled. We also see this with bank accounts. It's a very common way for people who do not have powers of attorney drafted, who don't see the value in this. They put a co-signer or a co-owner on bank accounts, which if I pass and I have a joint bank account, that person absorbs it. But if the downside of this is if there are other beneficiaries who thought they were entitled to that bank account, beneficiaries need to think again, because that co-owner, just like my home went from 50-50 to 101 person, that bank account went 50-50 to 100% in one person. So those beneficiaries become SOL, basically, causing the owner to the other person or co-signer to own everything in that bank account, and that avoids probate. My favorite way, at number 1, topping the charts here, folks, at the Campanile Law, whatever you want to call it, estate planning, probate tips. I don't know. I can't think of a name. It's early. I haven't had enough coffee. Beneficiary designations. I cannot stress this enough. This is my favorite way to do things. This is the best way to do things. This is the easiest way to do things. On your bank accounts, on your financial institutions, outside of your 401k. In previous videos, remember your 401k goes to your spouse. That's by law unless they sign a waiver. But name your beneficiaries on all of these accounts. Call your financial advisor if you're listening to this video right now and say, hey, have I named my beneficiaries? Some people haven't changed their beneficiaries in 25 years. They don't know who they are. And, they stopped talking to some of those people. So double check those. Name your beneficiaries. Give an exact amount, give a percentage if you want things to go away. This is a way to get outside of the probate process, and probably the best way to do it, because your financial advisor is going to be notified of your passing by your loved one, or if you have an attorney, after your attorney's been notified, to say, look, okay, start contacting the beneficiaries and start working with them. The financial planner or advisor will pick up the phone, send you an email, express their condolences, and then say, hey, what do you want to do with this? You're entitled to X amount %. So, from worst to first, transfer on death deed, not allowed in the state of New Jersey. Oh, poop, what was number 4? We had a transfer on death deed. We had the transfer on death was number 3. Number 4 was transfer on death. Number 3 was joint tenants with rights of survivorship. Well, that was 3 and 4. And number 1, why am I drawing a blank on number 4? That's going to bother me for the rest of the day. Anyway, number 1, beneficiary designation. Oh, gifting is number 4. How could I forget? 5, transfer on death deeds, not allowed in New Jersey. Number 4, gifting. I don't like it. You'll lose control of the assets, and you also could lose the step up in basis. Number 3, joint tenants with rights of survivorship / number 2, transfer on death, poor man's will, and number 1, beneficiary designations. I know this was a little bit of a longer video than we're used to, but this is a goodie. These are things that you can think about. So remember, if you have questions about estate planning or probate and you want to schedule a free strategy session over the phone with me, go over to njestateattorney.com right now and schedule a day and time that works best for you. These were the 5 ways to avoid probate without having to involve a revocable living trust. As always, my name is David Campanile. I'm an estate planning and probate attorney in the state of New Jersey. I own Campanile Law. Have a wonderful day.